Welcome to the Only Male Cruise Show, the podcast. I am the only male cruise. Be sure to hit the like button, share, subscribe, replay gang, leave a comment. You know I want to hear from you. Copyright disclaimer regarding fair use is in full effect. The views and opinions expressed in this show, you guessed it, they're all mine. Let's go to work. All right, y'all. Welcome to the Only Male Cruise Show, the podcast. I am the only male cruise. Be sure to hit the like button, share, subscribe if you haven't already. Replay gang, you know what time it is. Leave a comment. You know I want to hear from you. Shout out to Carla McWilliams. Thanks for pulling up. Appreciate everybody. Okay, so we're going to go through just a little bit of this motion that came down. I was just over there on in the chat of Lady D, and she was kind of going over what the state of Illinois has decided to do. And you know, I'm telling you, I think the only glimmer of hope right now is Jennifer Bongine, because the state of Illinois, they're trying to do things just a little bit different than what New York did. Okay, they learned some of the lessons from what New York was talking about. So that's how. In reading this motion, that's what I see they're trying to do. So I'm not going to get into the technicalities of all this, but I'm just going to kind of highlight some of the things that they came up with. So, for example, the government respectfully requests that the court grant the government's motion. And these three things: they want to permit the victim witness, which that's an interesting category, interesting designation. Permit the victim witnesses and minor one's mother to testify using their first names only. Okay. Two, they want to limit references to each of the victim witnesses and minor one's mother in open court to their first names only. And then they also want to prevent public disclosure of addresses, full names of family members, or exact places of employment, if any, for the victim witnesses, minor one's mother, and for individual D. Now, the biggest challenge here is trying to pinpoint who's on first and what's on second, who is individual D. And I think, and I'm not really sure, so I probably shouldn't hazard a guess, but I think that it's been stated before who this person is. I think allegedly it's Asante McGee, I believe. The court further requests that, or the government further requests that the court enter the attached protective order that sets forth the government's requested relief. So anybody that tries to actually move forward and if they get the first names and they think they're going to go through and burn up a car or something of that nature, they'll be happy to go ahead and try to, use that against Kelz. So I guess everybody needs to be on their P's and Q's. Shout out to Phyllis Gibson. Shout out to Kitty Queen. Thanks, y'all, for pulling up. Appreciate y'all. Let's see. So here's some other stuff. Motion to preclude evidence of victim's sexual history. For the reasons set forth below, defendants should be precluded from eliciting on cross-examination or otherwise introducing evidence or making arguments as to the sexual behavior of the victim witnesses with other individuals or with individuals other than Kelly or others at Kelly's direction. So this was very interesting, because what that tells me is and I don't know if Faith is going to be participating in this, but it sounds to me like with this particular request, they want to present these victim witnesses as though they're pristine, as though they've not had sex before, that they don't have a sexual history. So um, they don't want Bongine or any of the attorneys working on her team with her to uh, say, to ask, say, Jane Doe number 5, for example, weren't you in the hotel and didn't you say that after the police left, you got up on there backwards and Kelz got to doing what he did? They don't want this trial to expose or disclose that sex actually occurred. They still want to make this a very narrow field, is what this sounds like. This is why they're requesting this. Um, it says, by its plain terms, Rule 412 bars evidence of a victim's sexual history and sexual predisposition in cases involving allegations of sexual misconduct. So they don't want the jury or anyone else to know that these ladies were in a 4-year relationship freely, willfully engaging in sexual intercourse with R. Kelly. They don't want none of that brought up. The following evidence is not admissible in a civil or criminal proceeding involving alleged sexual misconduct. Evidence offered to prove that any alleged victim engaged in other sexual behavior, or evidence offered to prove a victim's sexual predisposition. So they're saying Rule 12 says they can't bring that up. So you can accuse Kelz of it, and you can read the charges that you have Kelz up on, such as underage, engaging with minors, this and 2/3, sex trafficking. You can say all of these things that would your common sense would say, well, he must have been having sex with these people. So you can make all those accusations against Kelz, but then when you look at the victim witnesses, they don't want you to look at them as though they got experience in the game and maybe had experience prior to even meeting up with Kelz. So that's just, it's biased already. Says, let's see, the purpose of the rule is to safeguard the alleged victim witnesses against the invasion of privacy, potential embarrassment, and sexual stereotyping that is associated with public disclosure of intimate sexual details, and to encourage victims of sexual misconduct to institute and to participate in legal proceedings against alleged offenders. So it's to safeguard them from that. So we know that there's some video out there where Jane Doe number 5's daddy is saying that she had a boyfriend and that didn't work out, and it turned out so bad that she wanted to, end her life and all of that. We know that, so we can't. So basically, what they're trying to say is, you can't bring that tape in. It's just too much. The purpose is consistent with other provisions of federal law, which provide that all crime victims have the right to be treated with fairness and with respect for the victim's dignity and privacy. Consequently, this rule is interpreted broadly and applies to all sexual behavior of the victim before trial, whether offered as substantive evidence or for impeachment. So they really just don't want none of this stuff brought up about the victim witnesses. Okay. It says Rule 412 imposes clear limits on defendants' ability to introduce evidence that a victim engaged in other sexual behavior, anything in the past, or has a propensity to engage in sexual acts. So going up to a concert and standing on a speaker twerking. Okay. In the context of criminal cases, the rule prescribes very limited exceptions to this inadmissibility. Now, if a defendant intends to introduce evidence of a victim's other sexual behavior or alleged sexual predisposition under one of these exceptions, the rule requires the filing of a sealed motion no less than 14 days before trial that specifically describes and states the purpose for which it is to be offered, with notice to the victim or her representatives, which Bongine could certainly work with. That wouldn't be no problem. But they're really trying to keep Bongine. It's like they're trying to narrow her down and prevent whatever they can. It's stated here that Kelly is charged with enticing each of the minors named in the indictment to engage in sexual conduct and acts with him repeatedly over the course of years. Here, any evidence of a victim's sexual behavior with anyone other than Kelly or others at Kelly's direction, as well as any evidence of any purported sexual predisposition, would be wholly irrelevant to the charges against the defendants. Now, can somebody put in the comments, does that make sense to y'all? That doesn't make sense. That's these girls, this ain't how it went down. Again, you didn't lie about your age. Multiple of them. Y'all did not lie about your age just to get an autograph. You didn't climb no fences when Kelz wasn't even there just for an autograph. You know what you came to do. And I know I can't remember the victim witness's name, all right? But one of them, she came to the spot with condoms. I think her name was Angela, allegedly, I believe. But she came to the spot with condoms, her and her friends. So, you know, but they want to exclude that. Now, the exclusion of evidence on these topics is thus appropriate. Prosecution affirming district court's decision to prohibit the introduction of evidence suggested of the minor's victim's sexual predisposition and her previous sexual activity with a male depicted in photos on her phone. Okay. All right. The evidence is inadmissible under Rule 4. I'm just skimming through here real quick, y'all. Let's see. Outweighed by the dangers, unfair prejudice. All right. Motion to bar evidence and argument related to consent. The government requests that the court prohibit defendants from introducing evidence and arguing that the minor victims consented to engaging in sexual activity while they were minors. It is well established that minors' lack of capacity to consent, and so sexual contact with a minor is always without consent, except when you lie about your age. Okay, you lie about your age. Nobody, and the person you're lying about your age to maybe finds this out later or never at all. Then, but you're going to charge him. You still want to charge him for that. It's a trick bag. It's a lemon twist. Let me see here. That the minor consents to engaging in prostitution is not a defense to the crime trafficking a minor for purposes of prostitution. All right, hold on, y'all. I got these highlights going on. Give me just a minute here. All right. It says, in this case, consent is not a defense to the charges in counts 1 through 4 and 9 through 13 of the superseding indictment. Whether any of the minor victims allegedly agreed to engage in sexual conduct with or at the direction of Kelz is irrelevant to whether Kelz is guilty of violating this particular rule. Therefore, evidence and argument related to the victim's consent is irrelevant and should be excluded at trial. How can the man defend himself if you're telling, how can he say, look, the girl jumped over my fence. I asked her how old she was. I checked her ID. We got it in. Now you telling me Kelz can't tell that? Kelz can't say that? They can't ask that girl if that's in fact what happened? Because you're saying that what's it say? Whether any of the minor victims allegedly agreed to engage in sexual conduct with or at the direction of Kelz is irrelevant? How's that irrelevant? If they lied. Come on now. Wait a minute. Let me check the comments because y'all tell me, does that make sense to y'all? Let me see. Let's see. Carla McWilliams says, yeah, that's not right. I bet one of them, got to be. When you say minor one and the mother, that's what I'm thinking. And they're making sure right now that they're establishing some parameters so they can't get in there and say, well, didn't you buy the tickets? Because they also, along with this motion, they also sent down, they have receipt or documents of the travel, and they also have minor ones. I put this in Lady D's chat. They have minor ones bank statements. And, you know, that's the trick. Who is minor one? Because I believe that the numbers, you know, you had your Jane Doe number 5 and your minor this and that. I think those numbers have been reassigned for this particular case, but I'm not sure about that. So And if I find out, I'll certainly let y'all know. Um, let's see here. This includes questions during cross-examination of the victims about whether they consented to having sex with Kelz or others while they were minors. Such questions would call for witnesses to make legal conclusions and should be barred. How's that legal conclusions? If she's testifying to something, if they're being asked, did you do this? Did you jump the fence and lie about your age? Lovable Leo said minor one is Lashana Landfair. Yeah, that is word on the curb. And I'm still just trying to understand, how are they still trying to try him for that? How are they trying to include that in the case? Because that is some good double jeopardy. So but that is word on the curb, Lovable. Absolutely it is. It says, for all these reasons, the court should grant the government's motion to bar evidence and argument related to the minor victim's consent. The government will offer instructions on this issue in its proposed jury instructions to be submitted at a later date. Okay, motion to prevent the public display of child pornography videos during the trial. The court should prevent the publication of child pornography video clips to the gallery during the trial. Now, they go on to say that, the reason why is because, it's pornography and the impact that's going to have on them as teens the impact that it's going to have on their life moving forward. It says here the overriding interest is the protection of minor one, who is depicted in the child pornography video that the government intends to introduce at trial. Okay. It says the Supreme Court has found that child pornography creates a permanent record of a victim's abuse, and the very existence of that child pornography causes the child victims continuing harm by haunting the children in years to come. It's really cute how they got this thing, dressed up like it's really just, like these were just innocent little bystander children, and children literally. And old Kelz, like I said, was just walking down the street, snatched one up by the back of their neck, and boom. Come on now. Government's intended evidence of polygraph examinations. Basically, now here's okay, let me just read to you. At trial, the government will present evidence about polygraph examinations that were administered for multiple witnesses who were involved in the recovery of videotapes produced by Kelz containing child pornography. So like all those payoffs that happened, allegedly, and then how it was stated that McDavid and them, Darrell and them, made them take polygraph exams to demonstrate whether they were telling the truth, that they had given up all of the videos. They're going to take those exams and they want to introduce that into as evidence against Kelz. It says, in summary, count 5 of the superseding indictment alleges that between 2000 and 2019, Kelly and Darrell conspired with each other, Individual A, and others to conceal and cover up the existence of multiple videos depicting Kelz engaged in sexual conduct and sexual acts with minors. It says, Kelz and Darrell learned that at least 4 of these videos, video 1, 2, 3, and 4, were missing from Kelz's collection of child pornography. In order to conceal and cover up the existence of videos from investigators, Kelz and Darrell and others agreed to collect the missing videos that depicted Kelz engaged in sexual conduct with minors. It is alleged that Kelz and Darrell paid hundreds of thousands of dollars to Individual A, Individual B, Individual C, and D in exchange for obtaining and returning multiple videos that they knew depicted Kelz engaged in sexual conduct with sexual acts with minors. As a condition of being paid money for returning the videotapes, the superseding indictment alleges that Kelz and Darrell directed Individual B, C, and D to take polygraph examinations regarding whether they had returned all copies of such videotapes. The indictment further alleges that, at the direction of Darrell, on Kelz's behalf, and this right here is enough reason to justify or to explain why Darrell doesn't want his case to be severed from Kelz, because now he can get on the stand and say, yeah, I did it, but Kelz told me to. So then when the jury comes back, and if they were to find somebody guilty, hopefully it wouldn't be Darrell. This, to me, that's what their reasoning is, or their strategy is, for Darrell's case not to be severed from Kelz. So it says the indictment further alleges that at the direction of Darrell on Kel's behalf, individuals C and D took polygraph examinations regarding the videotapes that individuals C and D had returned depicting Kel's engaged in sexual conduct and sexual acts with minor one and individual D. So that individual D has to be, it has to be McGee, allegedly, because that's the one who was in that, allegedly, in this threesome, or again, that's alleged, including whether there were additional copies of videotapes. So that's why they supposedly, allegedly, they had to take the polygraph test. But my question is this: is Kel's signature anywhere on any of this polygraph stuff? Who was present when the polygraph tests were administered? You understand what I mean? Was it just Darrell? Did Darrell show up and sit in the waiting room while the test was being administered? And who actually cut the check to the polygraph examiners? Because if Kelz was nowhere on there, how you just going to throw that on Kelz? All right. At trial, the government will call individual B, C, and D to testify about their involvement in the conspiracy to recover and return videotapes to Kelz and Darrell depicting Kel's sexual abuse of minor one. And also the fact that they're saying there were sexual acts with minor one and individual D. Individual D was a grown person. So that, again, is someone who should not be, quote unquote, a victim witness. That person should be a defendant, because you are allegedly did the very same thing that they are that they're accusing Kelz of. And so how come why aren't you on trial? Why aren't you fighting the case? Anyway, individual B, individual C, and individual D will testify about the communications that they had with the defendant about returning the tapes in exchange for financial compensation. They will testify about how, as a condition to receiving the promised payment, they were required to first take polygraph examinations about whether all such videotapes had been returned to Kelz and Darrell. The government also plans to call on more of the polygraph examiners to testify about their involvement in administering the polygraph exams of individual B, C, and D. Through these witnesses, the government will introduce testimony and documents related to the polygraph examinations that were administered on behalf of Kelz and Darrell. Administered on behalf of Kelz and Darrell? Okay. The documentary evidence, which is described further below, is relevant to the charged conspiracy in that it demonstrates that the witnesses were subject to such examinations about the videotapes as a condition to their promised payments from Kelz and McDavid. So again, who was present when these questions were being read? Now, if somebody was a client, was Darrell there? Come on. For example, the government anticipates that individual D will testify that in 2007 she was required to take 3 polygraph examinations geared at determining whether she had returned all copies of a videotape that she took from Kelz that depicted individual D having sex with Kelz and minor one. Okay, so that right there should have been enough to say, oh, I'm sorry, but you're under arrest, individual D. Individual D will testify that after passing the first 2 polygraphs, she received payments from Darrell and Kelz. In order to get the remaining money that she was promised by Kelz and Darrell, Individual D had to take a third polygraph examination. The government seeks to introduce documents related to Individual D's polygraphs, including dated consent forms signed by Individual D in which she agreed to take the polygraph examinations and release the results to Kel's attorney at the time. Who was Kel's attorney at that time? Let me scroll up real quick and check the year. Oh, oh, okay, 2007. Didn't we just go over some details where R.I.P. What's my man's name? Ed what? Jensen? When he did what? Okay. So how? Okay. All right. Okay. Dated consent form signed by Individual D in which she agreed to take the polygraph examinations and release the results to Kel's attorney at that time. Okay. Pre-examination interview, which, okay, listen. If Ed Jensen was Kel's attorney at that time, and Darrell is the one that was, because it's Kells and Darrell who are accused of facilitating this polygraph examination. That means Darrell had to have taken or had conversation with Ed Jensen about this polygraph and these videotapes. So how in the previous motions can, this was part of the argument that Bongine had, where Darrell's attorney was saying, we don't know nothing. We don't know anything. This is tricky. All right. Pre-examination interview forms completed by the examiner containing some general background information about Individual D, the examiner's notes listing the questions that he had asked Individual D during the polygraph examinations. These documents are relevant to show the dates that the polygraphs were administered, who administered them, and who would receive the results of the exams. Yeah, we want to know that. And apparently the state thinks they got it going on, because I wonder whose name is on there. And maybe Darrell was covering his jazz. I wonder whose name is on there, y'all. In particular, the questions that were asked during the examinations are relevant to establish the purpose of the polygraph examinations. As another example, the government plans to call Individual C to testify about how Individual D sent him a copy of the videotape that she took from Kells containing the video of Kells, Individual D, and Minor 1 having sex. After Individual C received the tape, he was summoned to Chicago to meet with Darrell about returning the tape. Individual C is expected to testify that before he left for Chicago, he made a copy of the full-length tape and only brought a shorter snippet of the tape with him. According to Individual C, once he arrived in Chicago, he provided the snippet to Darrell, who went into another room with Individual D. When Darrell returned, he told Individual C that he would have to take a polygraph examination. Individual C will testify that after he took the polygraph and failed, Darrell instructed Individual C to go home and get the original tape, or else someone would come visit him. Individual C understood Darrell's statement to be a threat. Individual C will further testify that before he left that day, Darrell paid Individual C $20,000 in cash as a down payment for going back to get the original tape for Darrell and Kells. So now y'all put something in the comment and let me know. Doesn't it sound, does this say anything that Darrell had to go and call Kells, or Darrell whispered in Kells' ear and said, tell me what to do now? It sounds to me like Darrell was freestyling. So you can't, y'all put something in the chat. Let me know. Does it sound like freestyle to you? Because it sounds like freestyling to me. It sounds like Darrell was handling this. Toria says, everyone knows who has common sense that polygraphs are inadmissible in a court of law because of the accuracy that have never they have never been used in a court of law. Yeah. So I think what they want to do is just show that um, they want to try. I think they want to admit or submit those as evidence, just so they can say, "See, Kelz and them was trying to just disrupt law and break the law and avoid being held accountable." But as we notice, based on what individual C is saying, he was threatened by the words that came out of Darrell's mouth, not Kelz. Not that Darrell called Kelz on the three-way and put him on the speakerphone and blase scoop. Wasn't none of that. Wasn't none of that. Shout out to Jason Finch. You're right. Free Kelz. Sir Miguel, it sounds as Darrell was doing. Yes. Sound like he was doing his own damn thing. Sounds like he acted alone and Robert knew nothing. He certainly didn't know nothing that day, Toria. Shannon Lewis says facts. Darrell and Lisa homeboy Keith M. And Darrell still paid the man $20,000 in cash as a down payment for going back to get the original tapes for Darrell and Kelly. The government anticipates that individual C will testify about the events that occurred after he returned to Chicago with the original tape. Specifically, individual C is expected to testify that he was required to take another polygraph examination about whether he had any other copies of the tape. According to individual C, he passed a second polygraph and Darrell paid individual C $80,000 in cash. And if any of y'all was at Lady D's live just about an hour or two ago, she made one heck of a point when she said, yeah, you pay it in cash, ain't no record of it. Because you ain't got to put $80,000 in the bank, okay? You ain't got to put that in the bank. Put it under the mattress. But how are y'all going to weave that together and implicate Kelz in that? Because again, we know, according to previous motions that Bongina stated, that Darrell had full and complete control of Kelz's finances. I wonder who are we going to find out actually made that $80,000 withdrawal? Okay, are we going to see Kelz at the ATM? Which you can't even take out 80 G's in an ATM. But are we going? Who are we going to see on the bank cam making that transaction, that deduction? Huh? Okay, Darrell. Let's see. It says here, including the consent forms, individual C. Hold on. $80,000 in cash. Okay. The documents created as a result of individual C's polygraph examinations, including the consent forms that individual C assigned, and the examiner's notes regarding his administration of the polygraphs, confirm individual C's trips to Chicago and meetings with Darrell, and are direct evidence of the conspiracy to conceal and cover up Kelly's sexual abuse of minors. Darrell may have done all these things, and clearly he did based on this and based on what individual C is going to say, but I see that, and they wouldn't have left this out, y'all, but I see that individual C is not saying, he ain't mentioned Kelz nowhere in it. So how do we know that Darrell didn't act on his own accord? Because this is what it sounded like. All right, argument. In this case, defendants use polygraph examinations as a tool to further their conspiracy to obstruct justice and recover illicit videotapes of Kelz engaged in sexual contact with minor one. During the conspiracy, defendants retained multiple examiners to administer polygraphs to multiple witnesses in this case, many of whom were subjected to more than one polygraph. This evidence demonstrates how serious defendants were about recovering the missing child pornography tapes and is admissible to show consciousness of guilt. Now, I'd like to know, what I'd like to see is the ones who failed it, like individual D. Oh, you failed it? because she failed. I think it said the third one. So what questions were asked on the third one that you failed? And again, all these times that these tests were administered, who was there? Who showed up as the client that the polygraph examiner was conducting the tests, on whose behalf? Who was there? Says the government seeks to introduce evidence and testimony about the polygraph examinations for purposes wholly unrelated to the substance of correctness of the results. So essentially they're saying we don't give a damn if they're right or wrong. We just trying to show you. It says here the government will not elicit testimony from witnesses about whether the results of the test were scientifically accurate, because they don't care. They just want to show that the tests were actually given. And I know Bonjean's going to say, so polygraph examiner, who called you? Darrell. And who showed up each time the exams are given? Darrell. Okay. And I submit a copy of the check that was paid to y'all. Whose signature's on there? Darrell. Oh, okay. Mm-hmm. Yeah. Yes. Let me see. Shannon Lewis says, put the link in her channel in the chat. I've never been to her channel. You know what? I'll tell you what I'm going to do, Shannon. I will post it on here. I'll post it on here when I'm done or mod pulls up. I don't see I got any mods in here tonight. But no problem. It's Lady D. She's beautiful, and she will certainly, she'll certainly give you some details. Sir Miguel, remember, Kelz went to bank right. Kelz went to the bank for the first time in 2019. Not only that, the president at SunTrust Bank saw some unusual activity going on with Kelz's account. Come through. Exactly. Who, when, and what, and where. I need all the docs. Ain't that it, Ashley? Ain't that it? Y'all be sure to hit the like button, share, subscribe if you haven't already. Replay gang, you know what time it is. Leave a comment. You know I want to hear from you. All right, so the purported results are only relevant insofar as they provide important context as to why Darrell required individuals. This is Illinois' own typing. The purported results are only relevant insofar as they provide important context as to why Darrell required individuals to take multiple tests, and why Darrell paid large sums of cash to individuals after it was reported that they passed the examinations. The government further represents that it will not use the results of the polygraphs to bolster the credibility of any witnesses and will not make any arguments regarding the scientific reliability of the polygraph examinations at trial. So somebody needs to, and I'm sure Bonjean got this part covered. That needs to be a jury instruction. They're going to bring up the polygraphs, and they're going to say that that they passed the first one and failed the third one. Jury, you are instructed not to consider that. Blase scoop de ville. But see, this works out nice and perfect for Darrell not to have his situation severed, because while this entire case is being heard, the jury gets to see Kelz. He's the most prominent person in here. So they get to look at Kelz, and they get to be told that the tapes were of Kelz. And then all Darrell has to do is get up and say, I was just doing what Kelz told me. You wouldn't do it if you were been for the first time. Come on now. I'm sure she will fight to get those polygraphs thrown out. The chain of custody will be the key, but the videotapes come through. Did these witnesses steal the tapes? The alleged tapes? That's purportedly. How did they get these so-called tapes? Good question. Supposedly they were stolen. And this is why money was being offered to give them back, and this, that, and 2/3. If the tapes even exist, because I'm going to tell you, here's my own conspiracy theory. With everything I've come to learn about Darrell, I think that this could be a whole little trick. Just, hey, Kelz, they got some tapes, man. They just stole some tapes, man. So we need to get some money, man. And you worked out this nice little sweet deal, Darrell, with all these people. And everybody got broke off. Okay? Everybody got broke off. But Kelz is on trial. Somebody, make it make sense. Okay, admission of the polygraphic evidence for the limited reasons set forth above is permitted under the Seventh Circuit law, blah, blah, blah. Sure, whatever you say, state of Illinois. All right, the same principle applies here. The government is not seeking to use the results of the polygraph examinations for their scientific value or to bolster the credibility of any witness. Rather, as alleged in the superseding indictment, Kelz and Darrell caused examiners to administer polygraph examinations in furtherance of their conspiracy to obstruct justice. It is also important to highlight that the offered polygraph evidence does not relate to polygraphs of any of the defendants in this case. Yeah, we know. As a result, there is no risk that the jury could make adverse inferences about the defendant's credibility, as the government is not offering evidence that any of the defendants took polygraphs. I mean, and so we know that's not why y'all asking for that. They think everybody's an idiot. We know that's not why y'all want the polygraphs, and we also know that's not going to be the reason why Bongine will possibly argue that stuff not even be administered. Now, what the grounds of her argument would be, I don't know. Mine would be, since she's only representing Kelz, would be, is Kel's name anywhere on the polygraph? Then no, we're gonna move to have those excluded. But again, that works for Darrell, especially if Darrell's names is all over these polygraph requisitions. It works for him to stay on trial with Kelz, so he can say, that black man over there, he the one made me do it. He made me do it. He the one told me. Okay, individual C said that you told him he better do what you tell him, or somebody gonna be to see him. Shannon Lewis said the same images on every major porno site right now, but people can make fake tapes. Exactly. How did they get these so-called tapes? That's what I'm trying to say. In some, evidence of where, or in total is what they're saying, in some, evidence of where, when, how, and why the polygraphs of individual B, individual C, individual D were administered is probative evidence of the conspiracy charged in the indictment, including, for example, one of the alleged overt acts that Darrell, acting on Kel's behalf, directed individual C and individual D to take polygraph examinations, and as such, this evidence should be admitted at trial. Man, they better have a smoking gun if they think that they should be able to implicate Kelz in any of this. The government provides, notice regarding introduction of the false records alleged in the superseding indictment. The government provides notice that it will seek to introduce certain false records alleged in count 5 of the superseding indictment. First, the government provides notice that it will seek to admit a memorandum summarizing an interview of individual D that took place on or about July 26, 2007. This memorandum, which is not hearsay, is relevant to prove that Darrell and Kelz conspired to obstruct justice as alleged in count 5 of the superseding indictment. Particularly relevant to this motion is the allegation in the superseding indictment that on or about July 26, 2007, Kelz and Darrell directed individual D to falsely deny that individual D and Kelz engaged in sexual acts together with minor 1. When Kelz and McDavid knew that Kelz had engaged in sexual acts with minor 1 and individual D. As Kelz and Darrell intended, a false record, document, and tangible object was prepared based on individual D's false statements. And again, I'm still not understanding why they didn't tell individual D to be quiet so that she wouldn't incriminate herself, because she gonna need a lawyer. They would have done that on CSI, or what's that other show? Y'all know what I'm saying? Law and Order. They would have been like, ma'am, we're going to tell you need a lawyer. But they let individual D hurry up and run this game and and admit to everything she participated in just so they could jam Kelz up. Leona Shaw said, vindicated. Toria says, people always want to holler America, ooh, is the best. We are a democracy. When we have the most crooked, ooh, girl, yes. When we have the most crooked government, our justice system sucks. And you're right, Toria. Let's see, Darrell, along with Barry Hankerson, was the culprits behind framing Kelz. Yeah, Law and Order and SUV, come on through. Come through. Please, Father God, in your name, they will not get away with this. Kelly's is coming home. All this is a come up. Free Kelz. Amen to that. Let's see. Now, stating here, as set forth above, individual D was summoned to Chicago multiple times in 2007 in connection with Darrell and Kelz's efforts to collect contraband videotapes and impede the Cook County criminal prosecution in 2008. Individual D was required. And now, see, that tells me that I can't remember who in the comments said this, but it may very well be the Lashana girl. Because it's the way they're alleging it, that all this happened to impede the Cook County criminal investigation or the Cook County criminal prosecution in 2008. Individual D was required to take multiple polygraph exams to assure Kelz and Darrell that she had returned the video she took from Kelz that depicted herself, Kelz, and minor one engaging in sex acts while minor one was around 14 years old. Individual D is expected to testify at trial in this case that, following her third polygraph exam on or about July 26, 2017, that Darrell told her to meet with other lawyers and tell them that she never had sex with minor one. Individual D is expected to testify that Darrell waited in the hallway. Oh, so he was present? Oh, okay. Hi, Darrell. Individual D is expected to testify that Darrell waited in the hallway as she went in the room to meet with the lawyers and provide them with false statements as instructed by Darrell. A memorandum of interview dated July 26, 2007 was prepared, documenting individual D's false statements. In summary, the memorandum states that individual D provided the following information. Between 1997 and 2006, individual D had sex with Kelly and multiple other females, all of whom were over the age of 17. Individual D knew minor one and had spoken to her on numerous occasions. Individual C, or as you were, individual D, never saw Kelz in a sexual situation with minor one. Minor one was never a participant in any sexual encounter with individual D and Kelz. Individual D agreed to be interviewed by attorneys on July 26, 2007. Individual D was not forced, threatened, or promised anything to participate in this interview. So what you're saying here then is, this is what it says here. In summary, the memorandum states that individual D provided the information I just read to y'all. So was you lying then, or is you lying now? Was you lying on the polygraph or not? And to me, that's one of the reasons why you don't want to the government doesn't intend to submit the scientific aspect of the polygraph test, because that's a great question. You passed these two, but you failed this one. What? Where's the truth at in all this? And again, this is to me, and why are we prosecuting Kelz in a case for something he was already tried for in 2008 and acquitted? And that's why y'all came up with this RICO, so y'all could get him. Okay. At trial, the government will question individual D about this memorandum and lay the foundation for lay the foundation for the memorandum's admission into evidence. The memorandum should be admitted as the statements therein are not being offered for their truth. Quite the opposite. The government seeks to use this document as evidence that she was coerced by Darrell and Kelz to provide false information about her knowledge of minor one and Kelz's abuse of minor one. The government's evidence will further show that on or about July 26, 07, individual D received a $30,000 payment from McDavid. And again, this was also the bank statements for, I think it's individual D, minor one, minor one's mama, Darrell and them. All of that was submitted along with this motion today. So, in addition, the memorandum is not privileged. After the memorandum was prepared, Kelz's attorney at the time provided the memo to the assistant state's attorney assigned to Kelz's criminal trial in Cook County. The Cook County State's Attorney's Office, in turn, provided a copy of the memo along with the correspondence from Kelz's attorney to the U.S. Attorney's Office, and the memo has been produced to the defendants in this case. Look, y'all, that is, let's see. I might just have this motion right here. Let me see. Yeah. Okay. So I'm looking real quick at this motion that Bongine submitted when they said they want to sever the trial from co-defendant McDavid to sever counts 10 through 13. In this particular motion, I'm trying to flip these pages, where Bongine says, I don't know anything about this, but Darrell's attorney seems to know more. I'm trying to, let me see. I'm just going to, I don't want to have y'all on hold too long, y'all. Okay, but I'm just trying to see if I can find that part. Because Bongine does address that. She's like, it's interesting. It's interesting that, this man is his lawyer, but there's some issue. Okay. I may just have to post it on my community or come back on another time and go through that. But let's keep going through here. All right. Cook County State's Office Attorney General Office provided a copy of the memo along with the correspondence from Kelz's attorney, which had to have been Jensen at that time, to the U.S. Attorney's Office, and the memo has been produced to the defendants in this case. Second, the government provides notice that it will seek to admit a police report containing false information provided by minor one during the Chicago Police Department's investigation of Kelz in 2000. As alleged in the superseding... Okay, let me just stop real quick and say this. Now, y'all know how Jane Doe went to... She was in a house. They was in a hotel, and Jane Doe's parents called the popo, and they pulled up, and Kelz said, "Get some clothes on." So he told her to go to the bathroom, put on some clothes, and he said, "Are you 18? What? Are you 18 or what?" She's like, "Yeah." So he opens the door, and the police say, "Blase scoop." They ask for Jane Doe's ID. She shows it to them, and it shows 18. The police had Jane Doe's parents on the line. The parents said she is 18. She's over and above. So that was all well and good. So, but here you want to admit a police report containing false information provided by minor one during the Chicago Police Department's investigation of Kelz in 2000. So I'm a little lost here. Wow. Okay. Anyway. As alleged in the superseding indictment, approximately December 2000, pursuant to the instructions that minor one received from Kelly, minor one falsified and caused a false entry to be made in a police report when minor one denied to law enforcement officers that Kelz engaged in a sexual relationship with minor one. At trial, minor one is expected to testify that Kelz began having sexual contact with her beginning around 97 or 98 when minor one was 13 or 14 years old. I don't know if anybody in the chat knows, but when did Kelz find out how old this girl was? You know what I'm saying? I don't know if that was ever disclosed. I don't know if anybody knows. But I would like to know. Because I saw the videotape. And the girl didn't look 13, 14. Okay? She did not look 13, 14 years old. Shannon Lewis says, would that be a conflict of interest if RL was putting dollars on Rob's books? RL. Who's RL, sweet love? Tori said they must have gave him immunity. Yeah, they had to give them all immunity. But I thought this was so important that this minor, their rights, especially how you going to give immunity to individual D when the last I heard she was 19 or so when she met Kelz. So that means she was willfully and wholly involved in the same crime that you got Kelz on trial for. So how she get immunity? Thought you wanted justice. D was supposed to be on the tape, then she can be charged. He was just taking Robert's money and giving it away. Yep. Sure, most went in his pocket. You already know. They want to bring the charges and dictate how Kelz, girl out there ain't that it, and dictate how Kelz can defend himself. This is crazy. I call BS. Darrell worked for Barry Leona, girl, you kidding. Breaking news. I didn't know this. Darrell worked for Barry before he became Kelz's accountant. He was sent in by Barry because Barry was mad. Kelz fired him for stealing his money over and over and over again. My goodness. They checked her ID. Yeah, Toria, if you're saying they checked minor one's ID, okay? And you know what? Even if they didn't check minor one's ID, Kelz was acquitted of that. So how are you trying them again? And we do know that Kelz was asking for ID from Geronda. According to court documents, allegedly, I'm just going to say, we know that he asked for ID, he checked the ID of Azriel. According to transcripts, that will happen in the hotel. Come on now. Come on. So Kelz has already demonstrated that he was trying to make sure that he didn't get caught back up in the lemon twist. He's checking IDs. How is that supposed to fly when he checked ID? And the parents said she was 18. Bongine found out everything. It's going to all come out real soon. That's why this Illinois trial, that's why they're trying to really narrow the lane that Bongine can go down. So I do not think they ever told when the truth about their age was discovered. Yeah. Okay. Thank you, Miguel. Thank you, sir. Appreciate you. Yeah. Okay. Yes. Appreciate y'all. Y'all be on it, boy. Right on, y'all. Yes. All right. Susan Loggins. Oh man. It's doing too much, y'all. It's just doing way too much. Let me get back to this. Now, where was I at? Made a false entry to be made in a police report. Minor one denied to law enforcement officers that Kelz engaged in sexual relationship with minor one. At trial, minor one is expected to testify that Kelz began having sexual contact with her beginning around 97 or 98. When minor one was 13 or 14 years old, when minor one was about 15 or 16 years old, in or about 2000, certain government agencies began investigating allegations that Kelz was sexually abusing minor one. Kelz instructed minor one on how to act and what to say if she was questioned. In or around December 2000, law enforcement officers from the Chicago Police Department questioned minor one about sexual conduct with Kelz. During the interview with CPD, minor one falsely denied the allegations of Kelz sexual misconduct and documented that information in a police report. In summary, the police report states that law enforcement intervened, or as you were interviewed, minor one, who stated that she had never been sexually abused by Kelz and that any such allegations are untrue. So that was a lie or the truth then. So what you gonna do? What's your testimony? How can we believe your testimony coming up? How can we believe your testimony coming up? Especially if you took money, supposedly, allegedly. How can we believe anything you got to say? Especially when the other person is going to get on there and testify with you was of age and says, yeah, I did it. But y'all ain't got her in a trick bag. Y'all didn't put her in a lemon twist. Come on, y'all. At trial, the government will seek to admit the Chicago Police Department report into evidence. Admission of this report is permissible as it is not hearsay and is being offered to prove allegations in the superseding indictment. For all these reasons, the above described records should be admitted into evidence. Government's notice of intent to admit direct evidence of crimes charged. As set forth in the superseding indictment, Kelly is charged with multiple crimes related to a sexual abuse and exploitation of 5 minors over the course of several years. Counts 1 through 4 and counts 6 through 13. The indictment further alleges that Darrell knew that Kelly was sexually abusing minors and that Kelz made several videotapes documenting the abuse. That's count 5. That's count 5. And Darrell ain't gonna do nothing but get up and say, he made me do it. He made me steal his money. He made me do all of it. That's why they don't want to sever. Kelz and Darrell went to great lengths to cover up the abuse, including paying large sums of money to witnesses to ensure that they would lie to law enforcement about the criminal conduct. In furtherance of Kelz and Darrell's conspiracy to obstruct justice, it is alleged in the superseding indictment that Kelz used physical abuse, violence, threats of violence, blackmail, and other controlling behaviors against victims so that Kelz could maintain control over them, preventing them from providing evidence to law enforcement and persuade them to continue to abide by prior false statements relating to Kelz's sexual contact and sexual acts with minors and videos of such conduct. At trial, the government will introduce testimony and evidence of the physical, emotional, and sexual abuse that Kelz inflicted on minors 1, 3, 4, 5, and 6 over the course of several years. Is any of these minors, were any of those receiving $5,000 a month? Purses and cars? Parents was the ones that bought the flights? The tickets? You left and came back? You left at will? There's a video of you out here shopping? Downtown Chicago? The victims will testify about how Kelz used violence and threats of violence and threats of violence to control, manipulate, and isolate them all. And y'all notice every account that these ladies give, it's always, well, see, I had who was that? I think it was Faith. It was on one of these shows. Actually, I saw this on they played a segment of it on Mad Pill. So y'all be sure to check them out on YouTube because they are good for a Friday, Saturday night show. Y'all just get your drink and sit back. But they played a segment on their show where where Azriel's mom said, if I could do it all over again, I wouldn't have bought them tickets. So, the mom wouldn't have brought them tickets. And the minors, and then Mad Pill's channel also showed where Faith was being interviewed, and she said, well, I called him and he wouldn't answer, and I called him and he wasn't available, and I called him and I couldn't get out the room. And like Mad Pill and them made the correlation. You had a phone, you were locked in a room, and you couldn't get out, and you didn't call 911 on your own? You didn't call nobody, but just kept calling Kelz, but you was stuck? So how are you going to tell me, or how are you charging government will introduce testimony and evidence of the physical, emotional, sexual abuse that Kelz inflicted on minors. The victims will testify about how Kelz used violence and threats of violence to control, manipulate, and isolate them with phones? And isolate them all as a means to coerce the victims to have sex with Kelz and prevent them from reporting Kelz to the police. For example, the government expects that minor 1 will testify that Kelz began hitting her when she was around 17 or 18 years old. Minor 1 will also testify about how Kelz isolated her from her family and friends and controlled her every move, including who minor 1 was allowed to talk to. Okay, so see, now that's where it doesn't sound like your girl. That's where it doesn't sound like the girl in 2008. Anyway, we're going to find out. Because to my knowledge, minor 1, if minor 1 is Sparkle's niece, and that's what the allegation is supposed to be, allegedly, the girl only came over there and got picked up. You understand? Even I haven't heard where Sparkle said that the girl stayed over there years and years, or months and months and months. So I don't know. This trial needs to come through so we can see who's on first and really understand who's telling them the lies. As another example, Minor 5 will describe the strict rules that Kelly had regarding who Minor 5 was allowed to speak to, and that Minor 5 had to seek Kel's permission before interacting with other men. According to Minor 5, there was one instance where Kells punched a man after he told Minor 5 that he thought Minor 5 was cute. Okay. In short, Kells used physical violence. Wait, Kells punched a man, but he didn't punch Minor 5, so y'all, does that make sense? That don't even make sense. Okay. In short, Kells used physical violence and emotional manipulation to entice and coerce the victims to have sex with him. Thus, testimony about how Kells hit or otherwise inflicted physical violence against the victims is direct evidence of the charges. Evidence of Kells' physical abuse is also direct evidence of the charged conspiracy to obstruct justice, which alleges that between approximately 2000 and 2019, Kells used physical abuse, violence, threats of violence, blackmail, and other controlling behaviors against the victims so that Kells could maintain control over them, prevent them from providing evidence to law enforcement, and persuade them to continue to abide by prior false statements relating to Kells' sexual contact and sexual acts with minors and videos of such contact. As a result, Minor 1's testimony about Kells' physical and emotional abuse of her while she was an adult is also direct evidence of the charge. Okay. There's a lot more on here, y'all. And there's a lot more on here. And it's just so much. It's just don't make no sense. Motion to preclude argument of evidence designed to elicit jury nullification. Let's see what they're saying here. The government moves this court to preclude the defendant from arguing or otherwise presenting evidence or pursuing lines of inquiry designed to elicit jury nullification. What? It is well settled that it is improper for a defendant to suggest in any way that the jury should acquit defendant even if it finds the government has met its burden of proof. They are real. They not only are they trying to hem Kells up, but they're trying to hem Bongine up. They state some case law here that pretty much is just saying any unreasonable jury verdict, although unreviewable if it is an acquittal, is lawless, and the defendant has a right to invite the jury to act. Okay. Jury nullification is a fact because the government cannot appeal an acquittal. It is not a right either. It is not a right either of the jury or the defendant. Okay, so they're going into detail about not allowing them to do a jury nullification. Therefore, the defendant should be precluded from presenting argument or evidence designed to elicit jury nullification. That's going to be one to watch, y'all, and really one to know more about. The government cannot anticipate each form of potential jury nullification argument or evidence. The government moves to exclude the potential areas noted below, all of which are irrelevant to the elements of the crimes charged, as well as any argument or questioning, no matter what its form, that in effect would encourage a jury to acquit under any circumstances, regardless of the law or proven facts. Wait, hold on. A motion to preclude argument or evidence concerning potential penalties faced by defendants if they're convicted. I'm trying to see. It says listed below. So let me see what they're talking about this. Okay. The government moves the court to preclude defendants from introducing evidence, making argument, or otherwise mentioning the potential penalties faced if convicted. For one, the Seventh Circuit pattern criminal jury instructions include an instruction specifying in deciding your verdict, you should not consider the possible punishment for the defendant. If you decide that the government has proved the defendant guilty beyond a reasonable doubt, then it will be my job to decide on the appropriate punishment. Okay, so basically, they want to make sure that the jury is told, don't worry about how much time Kel's going to get if y'all find him guilty. Don't worry about that. That's stay in your lane. That's the judge's lane. They coming out the gate trying to hem up Bongine. Let me see. See. Alvira said, I can't wait to see what Ariel gonna say. She visits Kelz in New York. Her dad worked for Kelz for 100 years. You know what? And Alvira, I think I saw that in somebody else's chat. Why do I have a feeling that Bongine would not permit that? I would need to see the visiting list to because I don't think that Bongine would permit that, knowing that she is an adversary in the court of law to Kelz. But stranger things have happened, right? Leona said, if you read Kel's book, you will then know how this all started, even how Barry was getting paid for Kel's concerts, performances, all the while telling Kel's it was promotional. My goodness, y'all, they done took advantage of our man so bad, it don't make no sense. Alvira said, RL dad worked for Kel's for years. She didn't live with Kel's, and her dad was there touring and everything with Kel's. The venues was paying Kel's only. Barry was getting the monies, not Kel's. They are trying to tie his hands so he can't fight properly. Facts, Bree. Ariel is not going to lie on Kel's. The government is just putting out propaganda. Shut your mouth up, girl. Hope that's true. Bottom line, Kel's is coming home. All truth will be shown from 2002 up until now. Watch. I believe that. Yeah, that's BS. Normally, after any verdict is out, they will instruct them on sentencing. So why, if he wants a jury trial, is the judge going to decide his fate? Right. Well, and that's my thing. I don't know if state law, because in some states the jury gets to make the sentencing recommendations, and in other states they don't. The judge does it. So said the dad passed away not very long ago. He played an instrument for Kel. She visited him before we knew she was just. Oh man, wow. Let's see what's tea, y'all. Hold on a minute. Argument and evidence concerning punishment are improper because the law is well settled that the potential penalty faced by a defendant is irrelevant to the jury's determination of guilt or innocence. Mention of the potential penalties faced by defendants only would serve the improper purpose of jury nullification. Yeah, I need some more details on jury nullification, y'all. Accordingly, the defense should be precluded from mentioning or introducing evidence about any of the range of penalties faced if convicted. The government moves to exclude evidence or argument by counsel of outrageous government conduct. What? Oh. See, they are. Oh, let me see. Hold on. They're stating a whole bunch of laws, so I'm trying to skip over this law. Saying outrageous government misconduct is no defense to a criminal charge. Now, one thing might be, because remember, Bongine put in one of her motions to New York, how they brought in, they might as well have did Surviving R. Kelly Live in the trial, because they that's damn near what it was. And so I wonder, is this what Chicago is trying to ward off? Says, furthermore, this circuit court held that the issue of government misconduct was a matter of law for determination by the court. Okay. Yet there is a tendency in criminal cases to try some person other than the let's see here. Hold on. Yet there is a tendency in criminal cases to try some person other than the defendant and some issue other than his guilt. The thrust of the defense in these type of cases is the prosecution was not nice or could have done it better, and so the jury ought to acquit. Whether or not guilt has been proved beyond a reasonable doubt, blah, blah, blah. Hold on, y'all. I'm trying to get to the specific details they're making about Kelz. Let's see. Accordingly, the government moves to bar the defense from introducing evidence or argument of outrageous of outrageous government conduct. Motion to preclude argument and evidence regarding the government's motivation in investigating and prosecuting the case. Let's see what they're talking about. The government moves to preclude evidence or argument by defense counsel regarding the government's and the officers' and agents' motivations for investigating or prosecuting this case. This includes, but is not limited to, arguments that the federal prosecution of defendants for child pornography offenses after Kelz acquittal in Cook County Circuit Court is vindictive or otherwise improper. Evidence bearing on the government's decision to prosecute is extraneous and collateral, and thus excluded from trial. Further, the government moves to preclude the defense from arguing or eliciting evidence regarding the mental states, subjective intentions, or motivations of the investigating officers and agents. It is well settled law that inquiries regarding the subjective intentions or motivations of a government agent are irrelevant to determining the factual guilt or innocence of a defendant. Bongine is going to eat this up. The question is the judge going to be fair and say, wait, hold on? That's what's going to be. Ah, shoot. Yes, bull. Normally after any guilty, they instruct them on sentencing. Hold on, y'all. Let me see. Tori said, oh, Mel, the feds are now building a case on Trashy K and the correctional officer for her buying his prison info. Story broke today on a live Gossip Alley radio show. Y'all know I'm going to be on it. I don't care who else covers it. I'm going to cover that one. Do anyone see how the Clarys and Savages are? Yes, Leona. Absolutely. And the question is, why? Are they part of the lemon twist? Or has everything that has come out now about them, does that have them on hush mode? I think they got a lemon twist. Or they think they got a lemon twist for Kelz, but they ain't got it. I think Bongine gonna come through with everything. They don't want the folks to know they are trying to redo the 2008 case. They really want Bongine to just stand up and say, we quit. Yep. They can't control how a person defends himself. Alvira said the potential jurors already know about the 2008 case, and they will know it when they hear it, because this will definitely be a repeat. Accordingly, the government moves to preclude evidence or argument by the defense regarding the government's and officers and agents' motivations for investigating or prosecuting the case. Motion to preclude argument and evidence of selective prosecution theory. Let me see. Similarly, defendants should be precluded from introducing evidence or argument seeking to present a theory of selective prosecution before the jury. Okay. During the trial, the government intends to call witnesses who, for example, participated in the conspiracy to receive child pornography. Don't try to clean it up, y'all. The government anticipates that defendant may argue that some of these witnesses may have been engaged in unlawful receipt of child pornography and may not have been charged with any criminal offenses. Pursuant to federal rules of evidence 401 and 403, such information is irrelevant and unfairly prejudicial. That's some... Okay, so they state some more case law that says that the court granted on relevancy grounds the government's motion to preclude the defendant from introducing evidence that another individual who had been arrested with him was not charged. And so ruling, the court noted that the primary issue for the jury was whether the government met its burden of proof as to the defendant's knowledge and whether or not not whether or not an individual was criminally charged. Okay. In the same vein, defendants should be precluded from making legally irrelevant and prejudicial arguments regarding the parents of minors 1, 3, 4, and 5, and 6. So you see them. That's why they quiet. Where's that comment at? Hold on. Yeah, right here. That's why they quiet, allegedly. Because Illinois has moved that, we can't say, well, why didn't you bring the parents up? The mom drove her to Florida. The mom started this whole thing when she texted Kelz playing like she was Jane Doe number 5, blah, blah, blah. The mom drove her to Florida and hooked up with the rooms and this, that, and 2/3. So they already, this is why. Because Illinois must have told them, don't worry, we got you. We ain't gonna let them harm y'all. We ain't gonna let them call y'all out. And we ain't gonna let them ask us why y'all ain't sitting right beside Kelz in an orange jumpsuit too. All right. To prove the offenses alleged in the superseding indictment, the government expects to present evidence that some of the minors' victims spent a substantial amount of time with defendants and that defendants may try to deflect the blame for their criminal conduct by offering evidence that the parents of the minor victims knew or should have known about their daughter's sexual relationship with Kelz. Defendants, okay, but see, again, at the beginning of this show today, y'all remember I mentioned that they said they can't bring nothing in. Illinois is moving not to bring any of the defendant's sexual activity at all. So if it says here that let me start from the beginning here. To prove the offenses alleged in the superseding indictment, that government expects to present evidence that some of the minor victims spent a substantial amount of time with defendants, that defendants may try to deflect the blame for the criminal conduct by offering evidence that the parents of the minor victims knew or should have known about their daughter's sexual relationship with Kelz. And that's a fair argument for Kelz and them to make. But this is why Illinois said, you can't bring up, we want the judge to say that Kelz and them can't bring up none of the victim witnesses' sexual history. Come on. So if the judge says, okay, that y'all can't bring it up, then Kelz and them can't say, well, y'all should have known we was knocking boots when the girl texted you and said it was going down. Defendants may further assert that to the extent the parents knew or should have known about the sexual relationships with Kelz, the parents thereby consented to such relationships. Such evidence has no legal bearing as to the offenses with which defendants are charged. Indeed, consent by either the parents or the minor victims is not a defense to such charges. Defendants may go so far as to argue that the parents of the minor victims were responsible, well, they talking about Jane Doe 5 here, that the parents of the minor victims were responsible for or aided and abetted defendants' crimes. Such arguments are legally irrelevant and would only serve as a distraction to the jury. Is that a distraction? Is it a distraction to ask, why did Jane Doe number 5's mama drive her to Florida? Why did Jane Doe number 5 sent her that text? I'm a girl, you need to do like this. Why did Jane Doe number 5 mama say, he gonna seduce you tonight? Huh? Why? Yeah. They tried it. For all these reasons, the government moves to preclude evidence or argument by the defense regarding any theory of selective prosecution. We're going to get a good idea about what kind of judge this is when we get the ruling on this motion. Motion to preclude discovery requests or commentary regarding discovery in the presence of the jury. I'm going to move past that one real quick because I'm just trying to hit the hot points right here. Motion to exclude evidence or arguments regarding the constitutionality of the statutes criminalizing the production and receipt of child pornography. Arguments pertaining to the constitutionality of the statuses criminalizing child pornography offenses are wholly irrelevant to the indictment in this case and do not affect Supreme Court, Seventh Circuit Court's unequivocal rulings that the First Amendment and Commerce Clause do not protect child pornography. I'm wondering why they're coming up with this motion because I haven't heard Bongine argue anything about that. So I wonder what prompted this. For these reasons, the government moves to preclude defendants from introducing any evidence or argument regarding the constitutionality of the statutes criminalizing the production and receipt of child pornography. Maybe there is a statute of limitations on that. I'll have to check that out. Motions to preclude argument or evidence of non-pertinent traits of defendants. Motion to preclude argument or evidence of non-pertinent traits of defendants' characters. The government moves the court to exclude all evidence offered by defendants of their lawfulness and or non-corrupt conduct, except reputation or opinion evidence offered by character witnesses strictly in accord with the limitations of federal rules of Evidence 405, other than testimony from character witnesses fitting within the narrow confines of Rules 405, no such evidence is admissible? Let me read that back real quick, because it sounds like what I just read was, you don't want anybody to come up on the stage and say, I was about to be 8 days without a meal and I seen Kelz and he bought me a meal, or Kelz paid this bill, or Kelz paid me $5,000 a month all while I was with. I mean, what? The government moves the court to exclude all evidence offered by defendants of their lawfulness and or non-corrupt conduct, except reputation or opinion evidence offered by character witnesses strictly in accord with the limitations of federal rules of evidence. That's going to be one to look out for, y'all, because I'm trying to figure out why are they doing, why this rule in particular, why this particular request. Okay, hold on. All right, let's see. Pursuant to this rule, only pertinent character traits or defendants are admissible, and all non-pertinent traits are inadmissible. For example, in an effort to distract the jury from the charges at issue, defendants may seek to call witnesses to testify that on a particular prior occasions, defendants followed the law or otherwise believed or otherwise behaved as lawful members of the community. You mean like checking for IDs? Is that what you mean? Any evidence or and checking for IDs and being presented with false ID? That's what y'all want to preclude? I get it. I see it now. Any evidence or argument of this sort is inadmissible, and the court should exclude it. The law is clear. Evidence that a defendant acted lawfully on other occasions is generally inadmissible to prove he acted lawfully on the occasion alleged in the indictment. Okay, so he acted lawfully checking the ID. You presented him with a fake ID that even police were fooled by, and then you subsequently knocked the boots, and now that you done caught him up, he can't say, I checked the ID? The girl jumped over the fence, I checked her ID, it was legit, we knocked the boots? Y'all want to leave all that out? Okay. To hold otherwise would be to eviscerate the carefully drafted limitations of Rule 405, which forbid proof of good character through evidence of specific acts where character is not an element of the charge or defense. Well, yeah. Okay, and it says this Rule 403 and Rule 405 is intended to prevent the series of wasteful mini-trials, which would inevitably ensue if defendants were allowed to introduce irrelevant testimony of non-pertinent traits of character. Okay, accordingly, the government moves to bar defendants from presenting argument or introducing evidence of character traits of defendants that are non-pertinent to refuting the elements of the offenses for which they are charged. I gotta read that again. Accordingly, the government moves to bar defendants from presenting argument or introducing evidence of character traits of defendants that are non-pertinent to refuting the elements of the offenses for which they are charged. They're trying to hem them up, y'all. Motion to preclude defenses of alibi or unavailability and mental defect. Okay. Motion to preclude defense counsel from defining the term reasonable doubt. They trying to hem Bonjean up, y'all. I think they only going to, at the end of this motion probably says, we ask that you only let Bonjean show up handcuffed, mouth tied, and not able to utter a word. Motion to allow government to recall the case agent during its case in chief. What? The government respectfully requests permission from the court to recall the case agent. Now, here we go, y'all. This is our Richard R. line. The government respectfully requests permission from the court to recall the case agent, a special agent from Homeland Security Investigations. No wonder OR line got out recently. During the course of trial, so that testimony can be presented to the jury in an orderly and understandable manner, and in a manner most effective for asserting the truth. The court has substantial discretion to determine the mode and order of interrogation. Hold on. I believe that's our line because that was a special agent, a Homeland Security investigator agent. Federal court will evidence. Hold on. Because the government intends to introduce, to the extent possible, evidence related to the conspiracy, which spans almost 20 years, and the substantive child exploitation charges chronologically, the government anticipates it will need to recall the case agent to testify about, among other things, voluminous bank and financial records, other business records from dozens of sources, and multiple videos containing child pornography. While the government will attempt to limit the number of times it recalls the case agent as best it can, requiring her to testify only once would necessarily require the government to cover a broad number of topics out of chronological order in a fashion that would likely confuse the jury. Accordingly, the government respectfully requests that the court permit it to recall the case agent to testify to the relevant episodes of the government's investigation. The government further proposes that after each instance of direct examination, the defendants be permitted to cross-examine the witness fully about any and all matters the witness testified about during the particular direct examination, so as to ensure a full and fair cross-exam. They didn't have to put that. Y'all already know Bongine. Kelz and them already have the right to do a cross-examination. So quit trying to put language in here like y'all really trying to be nice. This is not y'all's to give. That's their right to cross-examine the witness. Motion to admit business records pursuant to federal rules of evidence. Hold on, whose business records y'all want? They need to be asking for Darrell's business records. Records are an exception to hearsay rule if the following exists. Let me see. Under federal rule of evidence, certified copies of domestic business records are self-authenticating. If the party offering the records provides these adverse party written notice, it allows. And you're not telling me if you're asking for Darrell's. Still scrolling through here, y'all. Just trying to see. Okay. Other than reading everything verbatim, that's pretty much the extent. It says, for the foregoing reasons, the United States respectfully requests that the court grant the government's motion in limine. Hold on just a minute. All right. So that's pretty much it. That is the motion, y'all. It's just unbelievable what Illinois is asking for. I'm tripping. About to check these comments real quick. Sounds like 2008 all over again. That's facts. Can't wait for the judge to answer this. You going to get it, Mel? Yeah, I'm going to get it, girl. Shoot. Yes, Doria, I'm going to get that. I need to see. If you're talking about the Minnesota BOP officer, yeah, we're gonna see what's up with that, and how they're going to address the Tasha K portion about that. The parents knew a lot and allowed it. I got to see how Bongine is going to respond to this. And it's so interesting because this Illinois court knows good and daggone well that Bongine is handling Cosby's case right now. And this is a very detailed 43-page document. Okay, but we do know that Bongine has added at least two other attorneys on the team. And I would presume that they're highly qualified to go over this and respond accordingly, with Bongine's approval. They don't want him to fight. Just sit there and listen. Absolutely, Brie. Absolutely. And they want Bongine to sit there and just listen too. But they already know Bongine, and they know of Bongine because we know that she has already argued some Chicago cases successfully and won. So, and when her Twitter was up, the one guy that she recently got squared away, she had a picture of him. So on there, let's see, Alvera, how they going to dictate what reasonable is when the jury finds any, they should have quit. Yes. Reasonable doubt. How are they going to dictate what reasonable doubt is when if the jury finds any? They should have quit. Absolutely. Just come to court, Robert, with your lawyer and sit there. Don't say nothing. Don't do nothing. Just sit there and be accused while Darrell blames you too. Kelz told me to do it. Yes, Jason. Big wow on him. What about Sparkle niece, Rashawn? That's what I'm saying. And that's why I think that minor one, because again, they said minor one. We know that minor one, LaShonda was not, she wasn't, minor LaShonda was just in the studio, out of the studio, in the studio, out of the studio. And I know Sharon Winbush she's done a couple videos on her own, her knowledge of that. And we know that I think the parents would drop LaShonda off, or they would come with Sparkle, or they would drop her off and Sparkle would come later. But it was never one of those things where she was just there all the time. Plus, during that time, Kelz was still married to Andrea. So, what about Sparkle's niece, LaShonda? Right. They called out Darrell's name so much, and June Brown ooh, yeah, they did. Huh. That's going to be, but June got his own attorney too. So we're going to see about that. Let's see. Thank you very much, Mel, for reading this to us and giving us the info. Appreciate you, sister. I appreciate y'all. Y'all already know I do. I appreciate y'all for pulling up and sticking with me, supporting me. I love y'all for that. Make sure y'all hit the like button, share, subscribe if you haven't already. Replay gang, leave a comment. You don't want to hear from you. They're scared of Robert's lawyer. They know she is good at her job. She knows the law, not the law they learned in school. Girl, ain't that it? You're right. Free Kelz. Minor one was putting money in Kelz books, according to Tasha K. So where does that make sense? And that's the stuff they want to leave out. That's the stuff they don't want to be told. But I'm sure Bongine got some case law that says, wait a minute, how's this man supposed to be able to defend himself? Y'all if y'all don't want this stuff to come out, y'all need to drop some of these charges. That's what y'all need to do. And quit playing in Kelz's face. All right? Listen, y'all know I appreciate y'all a whole bunch. But that's it. That is the podcast. So be sure to like, share, subscribe, replay gang, leave a comment. And until next time, y'all, we will see you when we see you. Welcome to the Only Male Cruise Show, the podcast. I am the only Male Cruise. Be sure to hit the like button, share, subscribe, replay gang, leave a comment. You know I want to hear from you. Copyright disclaimer regarding fair use is in full effect. The views and opinions expressed in this show, you guessed it, they're all mine. Let's go to work.